Good morning. My name is Russ Sullivan. I am with Oasis Outsourcing. I'm here to walk you through this productive work environment, which is our harassment course that we offer every quarter, which fulfills requirements underneath AB 1825, AB 2053, as well as the new SB 396 pertaining to the new California requirements that are going into effect next month. So first and foremost, there's going to be a lot of you on this call. So what I'd like you to do is just remember you're muted, and there's a reason why you're muted because, you know, like I said, there's going to be a lot of us on the call. So if you want to interact with me, and I see a couple of you already doing that, well, just like Suzanne, she's going in through the question field. And up on the right-hand corner, you have a toolbar, and you have an orange little arrow in the upper right-hand corner. If you want to expand that, you'll have a question field. That's how we're going to interact. And just like Suzanne did, she started breaking out the good afternoons, and so I appreciate that. That's how you're going to engage with me. Now, what they're also doing as well is that I've noticed that in doing this over and over again, there's a lot of folks that might be sharing their computer with other people or in a conference room with other people, and I only see you on, and the other folks may not get credit. I want to make sure that they do get credit, and just like what Lisa is doing and Suzanne is doing, is that they're also in the question field giving me names of other managers, leaders, people that are attending this course in the conference room with them. So they're prime examples of what I would like to have done today. And more people are chiming in. This is perfect. This is exactly what I want. So if you can, go ahead and let me know who's attending that might be sharing a screen with you. You're more than welcome to do that in the question field, but this is also where we're going to ask questions, provide answers, all that type of stuff, and we'll go in here. This is so harassment, as we know, specifically in the media nowadays, is all over the place. And this can be a very good thing or a very bad thing, depending upon how it is viewed, how it is applied, and how it is utilized. And so this course is really designed for everybody to, you know, bring to the forefront of your mind. If you haven't been watching the media already, they're already in front of this, about how much of a hostile work environment can really ruin businesses. It could ruin the team chemistry, and, you know, really what we're trying to do is we're trying to create a productive work environment. Okay, so that's what you're here with me. It is 2 hours. I am letting you know that you are stuck with me for 2 hours. So tough it out. And that's part of the California law, right? So we'll talk about that in a minute. And I'll try to keep it as entertaining and engaging as we possibly can, but bear with me. 2 hours is 2 hours. So I do appreciate you spending time with us already on here. So let's take a look at this. You know, the first thing I want to bring to your attention is that as a supervisor or manager, it's really important for you to be able to, you know, recognize, prevent, and deal with sexual harassment or sexual harassment allegations should it occur in your work environment. Every single socioeconomic group at any level of education, any cultures and countries, age groups, so on and so forth, have been in some way, shape, or form and somehow been affected by sexual harassment. All right, and in the past, and we'll talk about it. It's just nowadays talking about it. It just call me weird, but every single day, folks, it seems like there is a new news article about somebody in some way, shape, or form that a claim has been, you know, filed against. Whether it's right or wrong, whether it's correct or accurate, is still yet to be seen. But it is every single day there is a new person that is being accused. Men, women, men on men, women on men, men on women, women on women. It doesn't matter. I mean, although prevalently it does seem to be more of the men on women, but it is across the board. I mean, this is just in our face now, and we've got to get to it. So I'm going to start off by saying every single claim, no matter what a position you are, everybody has rights and everybody has responsibilities. And if you're an employee, I'll just sum it up and then we'll go back through it again. If you are an employee, you have a right and an obligation to let the people know that whatever is said, whatever happened, whatever occurred is offensive to you. So you have an obligation to let people know that this is wrong. Managers, your rights and your obligations fall underneath this category. You need to take every single claim seriously, okay? It doesn't matter how you might assume it might be benign, but it may not be to other people. So you take every claim seriously. And employers, this is the trifecta here, employers have to make sure that their policies are up to date and in accordance with the latest laws and regulations that are within their states. Now, we got 50 states, obviously, and I don't know every single state law pertaining to any type of changes within any type of harassment, harassment policies, processes, but your RMs do, okay? And again, this one really targeting California. This one's really targeting, and Connecticut and Maine are in that umbrella as well. But employers need to be aware and generate policies, provide handbooks, and provide access to handbooks for their folks. Managers need to take those investigations seriously and actually do their due diligence. And employees, your responsibility is basically telling people no, tactfully, in some way, shape, or form. I mean, these are the big things. And if not, then you open up your organization for a world of hurt underneath different types of litigation. And it tends to be investigated by a group called the Equal Employment Opportunity Commission, EEOC. So we'll talk about that, and I'll dive into that a little bit deeper. But everything that I'm talking about is relevant, it's in your face, and it's something that we need to deal with today. Make sense? So I talked about a little bit of the California training requirements, 2 hours, covers a number of topics, have to have professional qualifications. Well, I've been doing this for over 20 years. Every quarter I do this for Oasis, and it is something that, I've been on both sides of the investigations. I've been on both sides of the claim as well. And I just want to let you know, pretty well qualified in every way, shape, or form to deliver this for you. There's a Q&A available. Obviously, if we're testing out the questions field, and thank you all for doing that. You already know how to use it. This is where we get to use your questions, right? And you don't need to be physically present. Hello, we're on a webinar, right? So basically, we've got that one covered as well. Make sense? So let's talk about what we're going to do for the next 2 hours, or 1 hour and 51 minutes now as I look at my clock. So here's the objectives, right? And I'm not going to read over them because you should be able to read over them on your screen, but I am going to define not just sexual harassment, but hostile work environment, which can be a sexual harassment underneath the sexual harassment umbrella, but also just hostile work environments where you got people being aggressive, not sexually, towards other people. But in California, that's called an abusive conduct, right? And we'll talk about that as well, and where some states bullying is an offense to others in the work environment. Man, look at all these people just sitting there hanging out with me. Good to see you. I appreciate everybody joining me today. And again, as you keep adding on, we'll keep getting you in there. So, okay. Any questions about this so far? If I killed you at all? Okay. then let's go through some of the laws. Not yet. No, I don't plan on killing you. No, hopefully I won't. I try to make this as relevant and entertaining as possible. Okay. So here's some things that are regulatory considerations that states, well, all states except for the last bullet point, truly embrace. Okay. First one is Title VII. Title VII is the Civil Rights Act of 1964. This tends to be the baseline of discrimination acts on the base of the protected classes, which are race, color, national origin, religion, sex. Since 1964, though, other changes have occurred. We've added on age. We've added on disability as protected characteristics. In California, I will let you know, and other states this is the same way as well, it's also illegal to discriminate based upon ancestry, physical disability, mental disability, medical condition, marital status, political affiliation. Yes, political affiliation. It is also illegal to discriminate towards based upon that in California, as well as genetic information, gender identity, gender expression, and sexual orientation. And we're going to talk about that new SB 396 amendment in this class. The EEOC is the Equal Opportunity Commission. It was actually created back in '64 to actually enforce the Civil Rights Act of 1964, but it really started getting teeth back in the '80s. And by its first rule, establishing the guidelines declaring sexual harassment that is a violation of Section 703 of Title VII, or what I call Title VII, really defining the criteria of unwelcome conduct of a sexual nature. That is what leads to sexual harassment. And it defined the circumstances under which an employer may be held liable and suggested affirmative steps an employer should take to prevent harassment up to and including these wonderful trainings, right? And that air quoting there. It's like they're 2 hours. We get them. The good thing is that you don't have to watch a video with the guy from the bad ties from the 80s and silly scenarios. These are real scenarios that I'm going to give you that have been in cases of law in which you go, really? And my answer is, yeah. These are just some stupid people doing stupid things. And they just don't get it. And in some cases, some people may not know that they're doing it, but in other cases, some people just don't get it. And I guess that's the best way to say it. So in addition to, we'll talk about those scenarios there, but let's take a look at the court decisions in 1986. And I'm really going to talk about one. It has to deal about sexual harassment can generate a hostile environment. And so that's where we start getting into the hostile work environment. And again, defining by the criteria that the EEOC about, sexual conduct that's unwelcome, evaluating the evidence of harassment, determining whether the work environment is sexually hostile, and holding employers liable for sexual harassment by supervisors. In other words, it's agents. They are agents of the organization. Therefore, employers, not just the individual supervisors, can also be held liable as well. In 1991, a provision was added to the Civil Rights Act that allowed employees to sue for compensatory damages for sexual harassment. So pain and suffering. That's really what this is. Before that, it was just back pay and attorney's fees. But now this pain and suffering, this compensatory damages were now added into the rights if the individual won their case. And that kicked in 91. And in 93, that hostile work environment was actionable as sexual harassment, even if it didn't really seriously affect the employee's psychological well-being. So it could just be applied or implied. And it didn't have to be traumatic. That's the best way to say it. right? So that was just some of the things in there. And then finally, actually starting on January 1st, California's updated some of the regulations to provide a deeper dive into transgender protection rights and required this training to include that as well. So this course also will dive into that later on. I mentioned about the EEOC, and they're the ones that define harassment. They're the ones that are established by Title VII. And in any course of training, California, Connecticut, Maine, we just want to bring this to your attention that all supervisors are required to take 2 hours sexual harassment on it. But let me dive a little bit deeper into the EEOC claims. Now, I'll tell you what, if you haven't been to EEOC.gov, EEOC.gov, there is a newsroom on that website. And what it does is it's a lot of information, and it's a lot of resources I use when I'm creating scenarios for our on-site courses or our webinar courses. They have last year, now I haven't got this year yet, but last year you can see that we had, well, for the last 6 years, basically, there's been a lot of charges. Now, a charge is what the EEOC does and files a formal charge against a business, okay? And that is basically where the EEOC has done the investigation, and it said, the charge means that you're going to get sued, or we settle. One of the two. But you are, whoever's complained and filed a legitimate complaint to the EEOC actually has a legitimate case, and they file these charges. When you go to EEOC.gov and you pop over to the newsroom, there's a lot, and it's not just for harassment. I want to let you know. For example, what was the one I was looking at today? American Airlines and Envoy Air to pay $9.8 million to settle a disability suit. So, I mean, EEOC gets involved with that. Where's the disability discrimination by Strataforce? There was, what was the one? Kaiser Aluminum for disability. What was the one? Buffalo Wild Wings was in here. You've got car dealerships. You've got loan settlements for discrimination, and what is called retaliation. So I'll give you an interesting data point here. So if you take a look, 97,443 private sector charges were done in 2016. That's expected to go up this year. And of those, almost half was retaliation, right? For the first 45 years of the discriminatory regulations that protect folks, race was the number one complaint, but for the last 4, it's been retaliation. And in fact, that is something that you need to think about, that it's a huge number, and you should see this on the screen right here. Here's a breakdown of all the charges. So retaliation was the biggest piece, with 45.5% of all charges filed, followed by race, then disability, then sexual discrimination, age, national origin, religion, color, Equal Pay Act, and then GINA. Everybody always asks me what GINA is. GINA is the Genetic Information Non-Discrimination Act. It was passed in the I think it was in the late 80s, early 90s, and it was really to help folks that there were some folks and some businesses out there that said, well, in order for you to join us, you got to take a blood test and blah 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 and that kind of stuff. And I don't know why they would do that, but some of the testing that was out there, you could find your national origin background. You could find out if the person was prone to medical disabilities, which might sway an employer not to hire you. But all that stuff is in there, and you can do your research. The big thing is that there's a lot of complaints out there, and there's a lot of different protected classes out there, and laws that prevent people from discrimination, and yet 97,000 charges were done last year. So there's still a lot out there. And by the way, it just doesn't have to be one, meaning that, for example, if you take a look at sexual discrimination, that was 26,934 claims last year. But it is typically also tacked on, or retaliation is typically added on to it. So a business can be hit with discrimination and retaliation, disability and retaliation, race and retaliation. See a common theme there? That's probably why retaliation is the big one. And I will tell you, in no way, shape, or form is it really easy to diagnose and interpret what retaliation is. It is like perception, which is 9/10 of the law. Retaliation is owned and interpreted by the person who is the victim. So if they perceive they're being retaliated against in some way, shape, or form, that's hard to prove against for an employer. So the first thing that you need to do is just make sure the environment is set up so there's not an element for retaliation. Make sense? It's just, when you go on to EEOC.gov and you go to the newsroom, you'll see a lot of that. Discrimination and retaliation, harassment and retaliation. You'll see a lot of it in there. So, just something that you need to think about. And boy, I'll tell you what, if you ever go on there and read those things, you'll go, oh, wow, really? There are some juicy, good stories about, people doing weird things. And it's just like, come on. We should be in an environment at work, at least where it's quasi-sane, right? So, just food for thought. Let's dive a little bit into the types of sexual harassment. And I've actually got 3 of them in here, and I'll dive into these about quid pro quo, hostile work environments, and constructive discharge. Let me give you an example about quid pro quo. Here it is. So you got an employee that's fired or denied a job or an employment benefit because they've refused to grant sexual favors because so-and-so complained about harassment. Right? Retaliation from complaining about harassment is illegal, even if it can't be demonstrated that the harassment actually occurred, and this falls underneath the quid pro quo category. So this example, and I'll give you more examples, it's just really, there's a position of authority there. And in that position of authority, it can be real authority or implied authority. And this is what I have on your screen now as we drive into the quid pro quo. We know that it means one thing or something for something, or one thing in return to the other, or this for that, however you want to do it. The key thing is when a supervisor demands that employees submit to his or her advances as a condition of the employee's job. Okay? And when I was talking about implied authority, I'm also saying, so it's the CEO's brother, it's the CFO's daughter, it is the owner's wife. It doesn't matter. They may not be a real employee, but because they are connected way up, it also means it could be an implied authority, right? It's just something, it only arises, quid pro quo does, in cases where a supervisor or a person in a role of authority uses their positional power to coerce employees in accepting their sexual advances. So, automatic liability, you hear some of it, being fired, being passed over for promotion, raise, less desirable work assignments. If you go into the EEOC.gov, there was an exact issue with this from Dunkin' Donuts. You got a manager at a Dunkin' Donuts, and I'm not sure exactly where they were. Manager kept on asking out this girl. She kept on saying no. So he switched her shift. Try to say that 8 times. He switched her shift into a less favorable work assignment because she wouldn't go out with him. And she sued, filed a complaint. Business didn't do much about it, didn't take it seriously, went to EEOC and won. All right? Several, tens of thousands of dollars in the charge as well. So it's just something that you need to think about from that perspective. That's being given less desirable work assignments. Well, let's take a look at this. And by the way, If you want to chime in, you are on the question field. You can chime in whoever you want to. I'm not going to read this verbatim, but here's scenario number one. We've got Erica. She's a leader. And Steve called her into the office talking about annual performance review, and she was, she's been really gung-ho and just really driving it, really a big champion for the business. And she's gunning for a lead manager position, right? So this is what Steve said. Steve said that the position was hers if you treated her right? And that, she wasn't comfortable with saying that. She took offense to that, told Steve that he would fire her, and Steve didn't care. This was a Matt Lauer incident. I don't know if we're going to use Matt Lauer, but I am going to use Matt Lauer because this is the same thing, right? If you've been diving into that, Steve said he would fire me if I didn't do what he wanted. It is one of those things of the Matt Lauer examples of I can ruin your career if you don't do this. I mean, this is quid pro quo. This is quid pro quo 101, basically, right? It is important to understand that with Erica has a valid case because her promotion was dependent on her willingness to submit to Steve's sexual requests. And if Steve was to fire or demote Erica because she rebuffed him, it would mean a significant and negative change to Erica's employment status, right? So she has all the underlying cases of quid pro quo on there. So, and by the way, the exchange of favors doesn't have to be blatant, by the way. It's just something to think about. One thing of note, if Erica had submitted to the sexual advance or comment, it would not necessarily mean that she is then prevented from ever making a complaint. Right? If Erica should change her mind, she can still complain against the supervisor who made the comment and file a charge if she should decide to do so. So remember, voluntary does not equal welcome. Right? So pop quiz, this is when you actually get on to the question field, and you're going to have to tell me which of the following examples illustrates quid pro quo. So I've got three options here. All you got to do is tell me which option is quid pro quo. Is it Jen is fired after refusing to submit to her supervisor's sexual advances? Is it Melissa's manager offered her some paid time if she completed some work that is usually assigned to Ann? Or is it Joe, coworker of Julie's, often makes sexually charged remarks and tries to caress her arm when they're done? So is it option 1, 2, or 3, or could it be more than one? It's up to you. So use your question field. Get in there, type. Here's your pop quiz. Okay. Good. A lot of people chiming in. Appreciate it. Awesome. You guys are doing good. I haven't lost you yet, have I? Good. 30 minutes into us. Oh, yeah. So we'll get into that. So first of all, let's go into the options. So which one is quid pro quo? The answer is number 1. So whoever, all of you guys that did number 1, you're spot on. So this is, submission to a supervisor's request for sexual favors as a condition of continued employment is an example of quid pro quo. Okay? Now, having to complete work duties, let's take a look for those that put in number 2. Some of you said number 2 could be quid pro quo, and it's not, so it sucks, but it's not any type of harassment because Melissa's manager offered her some paid time off if she did some more heavy lifting. It completed some work that is usually assigned to Ann, right? So that's not any type of quid pro quo. It's actually not any type of hostile work environment at all. It just sucks because you got to carry somebody's load. That's the big thing. Now 3, none of you marked 3 as quid pro quo. Joe, coworker of Julie's, obviously because Joe is a coworker, so there's no implied authority. He's just creepy, right? He's making sexually charged remarks and tries to caress around. That could be a hostile work environment, but it's definitely not a quid pro quo. Now, there was a question out here about what happens when there's no witness to the offense. Good question. Very, very good question. Can it happen? Can sexual harassment, quid pro quo, or hostile work environment happen in a vacuum between two people without any witnesses? The answer is absolutely it can. And that is this is why the investigations are so important. Okay, and we'll dive into that. But and so Lisa, you know, well, I'm going to table this question, but it's like really falls under how thorough of an investigation you have. But it's a great, great question, and I appreciate it so much. So good. All of you scored 1. Spot on. Thank you very much. For those that did 1 and 2, let's remove the 2. And anybody chimed in 3, 3 is a hostile work environment. It's not quid pro quo. So we'll just remove the 3 on that one. All right, so let's pop into next series again. So again, use your 1, 2, or 3. Which one would be considered quid pro quo? Is it option 1, where you have a female worker being told by a colleague that she should sleep her way to the top? Is it 2, supervisor propositions an employee for sex, promising him a pay raise in return, and the employee rejects the advance and is denied a pay raise? Or is it 3, a female employee accepts a date invitation from a male colleague? Good. Awesome. Absolutely. So here we go. So everybody's chiming in 2. So spoiler alert, it's 2, right? This is quid pro quo because the supervisor will only give the employee a pay raise in return for sex. Absolutely. So that's huge. Now 3 is interesting. It's not quid pro quo. If a female employee accepts a date invitation from a male, I mean, they're just dating. I mean, under no duress, you know, that's fine. Now, the key thing is that this is a slippery slope, though, okay? Because what happens if, you know, if the relationship doesn't work out? Then, boy, then you can walk into a big hornet's nest there. So, you know, we'll talk about that down the road because, you know, I'll give you some stories, but that's just got to be careful about dating in the workplace, right? It's inevitable. I mean, you can't really get you can't get you know. Oh, I forgot my train of thought. All right, I'll move on from that. Sorry. Let's talk about slide 15, perceived power. Again, I was talking about this. It doesn't have to have just, you know, real power. It can be perceived as like the CEO's brother, sister, so on and so forth, owner's wife, daughter, son, blah, blah, blah. Customer, best customer would be another one of implied power. You don't have to have authority to imply perceived power, right? So that's a big thing. Now, quid pro quo is still around. So I'm not going to say there is one that is used more, but this is the second one. Quid pro quo is used a lot now. Obviously, you've seen a lot of that in the media, and that technically is quid pro quo. Now let's talk about hostile environment. So a couple things about this. It's created by, again, the EEOC defined this as unwelcome sexual advances, requests for sexual favors, other verbal or physical conduct of a sexual nature. This form of harassment is not typically associated with the this for that element in the same way as quid pro quo, nor is there a tangible job detriment, loss of job, loss of role, something like that, or shift or something like that necessary to find or to cause a hostile work environment. A hostile work environment can be created by a supervisor or a manager, but also by coworkers who have no authority over the victim. So now you can get into clients. Now you can get into coworkers, peers, direct reports. It is important to note that the acts associated with hostile environment do not necessarily have to be overtly sexual in nature. Okay? It can be very subtle. Any unwelcome harassing behavior that is directed at someone based upon their gender can be considered sexual harassment, even when no sexual advances are involved. Okay? Some of these examples include pictures, calendars, graffitis, objects being utilized regularly, and that's some of the things. It may constitute verbal, physical, or both. And I want to say that here's an example. Somebody looking at somebody, staring at somebody, and glaring at somebody. I mean, that could be A, creepy, and B, unwelcome and make the other person uncomfortable. And that could lead down the road of a hostile environment. So, I mean, it's just, then, doesn't have to be physical where they're brushing up against you or touching you or constantly, like that first example. It could be a look. And it could be, the key is frequency, right? So the conduct that is hostile or patently offensive and repeated frequently. So those are the three qualifiers that could create a hostile work environment. Now, although, and I'm just going to throw this out there because there are court cases out there that say, although the pattern is repeated frequently, if the offense is so pervasive, right, and patently offensive, the courts now decided it could be hostile work environment once. Okay? So it doesn't have to be repeated over and over and over again. It could be bad, really, really bad. Excuse me. And that might be some of the situations. So it's a case-by-case basis, and if it gets to the court's going to look at it and determine, a couple things. But one is, would other people, a normal person, appear, determine your action or that action hostile from a sexual perspective? So it's just things to think about from that one. In a situation where the alleged harasser is a coworker or supervisor, well, it might be, it might be something simple, right? Because, it's a little bit easier, could fall underneath quid pro quo, could fall underneath harassment. But here's the thing about like this situation where others have joined in perpetrating harassment. Here's one where, maybe Michelle has been hired as an outsider for a senior position in a new firm, and her subordinates clearly resent her. Men or women don't like this new person who hasn't moved up the chain of command to take over this role. So on a regular basis, they blatantly refuse to acknowledge her authority. Many of them make sexist remarks about her. Men and women make sexist. That could be considered a hostile work environment. And again, I talk about unwanted sexual advances, leering gestures, suggestive objects, jokes, texting, sexting. What's the other stuff? Watching porn on television or on the internet. Hanging up pin-ups, magazines in the restroom, that kind of stuff. I say that because that actually did happen. Prior to here, I was director of a Flight for Life company. So Flight for Life, helicopters, so on and so forth. We'd have pilots at these bases with nurses and mechanics, and they all did a 24 on, 24 off shift. And, some folks thought it was okay to bring in their, sexual reading material and leave it just laying around in the bathrooms that everybody had to share, right? So, first of all, it didn't make any sense to do that because it's a work environment. Second of all, it's just weird, right? But, so people have vices and other people don't. Well, the fact is nurses complain, pilot wouldn't remove it, wouldn't get rid of it, just leave it out there. And so they went up the proper chains of filing the complaint, and literally we told the pilot, it's not appropriate. Any reasonable person would see that this could be offensive to somebody, and you either remove it or down the road we remove you. Your choice. Which would you like? And so the solution for the pilot, who was making a pretty good sizable chunk is that magazine's not worth his paycheck. So he got rid of it, all right? And again, if we ever saw any type of retaliation from him to these nurses, he could also be subject to further disciplinary actions. So a couple things about constructive discharge. And this talks about either retaliation or something to that extent. If you're an employee of California, you are actually employed in an at-will state. Now, this means that you can be terminated or demoted by an employer at any time for any reason without warning. But as a California-based worker, you can also quit your job without reason or warning. But sometimes when you resign, you may have done so due to working conditions that have been so intolerable and hostile that you simply have to quit your job to get away. And if you can prove that your employer actually coerced you to quit, you may be able to claim constructive discharge and sue for wrongful termination. So according to the California Supreme Court, constructive discharge, also known as constructive termination, occurs when the employer's conduct effectively forces you to resign. Even though an employee may actually quit the job and say, I quit, the relationship between you and the employer is severed involuntarily by the employer's negative behaviors or the intolerable working conditions. This means that the resignation was also against the employee's will, therefore more like a firing, in other words, than quitting, which is a constructive discharge. It can be quite difficult to prove, but I want to let you know that this comes into place. And underneath California labor law, for an employee to prove constructive discharge, there are some parameters that they need to prove. Okay, one is the workplace conditions were unusually intolerable. Okay, to make any reasonable employee want to resign their job. And two, the employer had knowledge of the intolerable working conditions and knowingly permitted them to continue, or the employer's intentions were to force the employee to quit his or her job. Now, this is not a sexual, hostile work environment condition, but it can be a hostile environment. So I want to let you know about constructive discharge and your rights as an employee. Make sense? So let's take a look at some scenarios. And again, you're going to need to tell me, is this sexual harassment? Yes or no. Ready? So we got Steve discussing design plans with Elaine, and she demonstrates a personal interest in Steve and tells him that that she's interested in going out with him, but her comments are not overtly sexual in nature. Based upon your questions field, here we go. Is this sexual harassment? Yes or no? Sweet. No? So it's like not sure. Okay, so in and of itself, when you look at this scenario, there's a couple of things. It can be, but in most cases, based upon as it is, it may not be, but it all depends upon how Steve interprets the information. So, is flirting at work always going to be considered sexual harassment? Again, consistent, pervasive, how the person receives and that flirt can constitute sexual harassment. But one thing as we're going into this and understanding these scenarios is the key about investigations, right? It is important when you're doing, if Steve does go to management and voices their concern, files a complaint against Elaine, there's some things you need to consider, like the history between the two, right? Had they been dating in the past? Have they been married in the past? Had they been a couple in the past? Have they, is Elaine Steve's work wife, right? It's a term that you hear about that. So it's some of the things that they need to think about that could constitute a hostile work environment. You got to look at this when you're doing the investigations. But what about if Steve believes that Elaine's is friends with his boss? Could that be perceived power? Could be. It could be quid pro quo in that case. It's just one of those things. If the woman's advances are not welcome, then Steve needs to let Elaine know. Okay, this is the employee's responsibility. You need to tell them to stop. Let's keep it professional. However you want to say it from a tactful perspective is just something you need to think about. Because recent rulings has emphasized the importance of employees making use of complaint procedures, but also telling the folks no, right, that this behavior won't be tolerated in order to protect their rights in the event of sexual harassment. Do you know your company's complaint procedure? Do you know where in the handbook the harassment policy is or the process of filing a complaint is? Is it postered up in your office somewhere? And if you don't know, or if it is outdated, this is where we come into play, because we can help either point you in the right direction, get your handbook set up correctly, or guide you through the appropriate process, right? So, capitalize on us. I guess that's the big thing we want to do. Make sense? Good. All right, here we go. Scenario number 3. We got Karen and Jane and their coworkers. And Karen needs to talk to Jane. Okay, I'm not gonna. You could read this, but have you ever met a hugger? Somebody that Karen greets her with a hug. Anybody that just hugs, and throughout the entire encounter, she's continually patting Jane's shoulder. There's not. Tact and timing is the big thing, but when you have a hugger, and there's nothing wrong with huggers, it's just you've got to. They got to know the boundaries, and other people got to project their boundaries. That's the best way to describe it, right? It is in some cases, and you're right, Pat, it could be awkward. But it also can be depends upon how long they've been working together, right? And this is just there are good people that hug, but it's like you got to watch people's boundaries. I guess that's the big thing. Even if the touchy person is innocent and their behavior, it's the victim's perception that counts. So Jane may be appearing uncomfortable, and Karen needs to pick up on that body language. See, that's the biggest thing, is that Karen needs to be aware of it. But Jane could probably do a better job of not just appearing uncomfortable, but also vocalizing, hey, in some way, shape, or form, it's not my thing. I may not be a hugger. There's not everybody that is a hugger, so it's a bit, it's just there's got to be that communication between the two. But also, Karen needs to pick up on that on that body language, right? So that's the big thing. The continually patting Jane's shoulder, though, that would even creep me out. It tends to be the torture, and it could be for some, right? So, it's weird. Scenario number 4. Now, let's read this. We got Mike and Raymond, and they're chatting, and Angela walks up, and they were talking about the beach, and she tells them that she had a great time at the beach with her family, and Michael says something stupid, right? But he's very disappointed he didn't get to see her in her bathing suit, and so Angela shakes her head and walks away. What's wrong with this picture, right? Couple things as we're going through this, and you need to, if you pick up on something, let me know. But let's talk about Angela. Angela shaking her head and walking away, is that a sign that she does not agree with what's being said, that she took offense? If you say, yeah, that's not acceptable, the answer is correct, right? She may have done a better job of verbalizing that, but obviously she does not agree with what's being said. So Michael, should have never said that in the first place, right? 2, should pick up on that body language and needs to respond. And that is from an apologetic perspective, right? It is more of, I didn't mean for that, it should take ownership in that what he said was stupid. But the key here is Raymond, because we don't talk about it, but Raymond also has a responsibility of calling out Michael's behavior. okay? If he's also aware of it, it's that third party thing in which Raymond should have called in duty or wrong. That was a stupid thing to say, and you need to go apologize, right? Because if you don't take that ownership and it continues, then we can go down the road of a claim or a charge or even up to and including litigation, right? And we don't want that. So nip that in the bud. Employees have responsibilities, and I keep on saying this, managers have responsibilities and ownerships have responsibilities. It's three legs of the triad. And even Raymond, who was listening to the whole thing, has an ownership and responsibility to let Michael know that was stupid. Okay, and then he needs to do it. Could this just one incident be the sort of behavior that results in a charge of sexual harassment? Probably not, right? But that behavior, if it continues, is severe, could be considered illegal down the road. So one joke or inappropriate comment is not likely to be considered illegal by the courts, but don't hold me to that, meaning that, if it gets in front of the courts, it tends to be the lawyer that argues the best tends to win, right? So I would say that don't even get it to the court side, right? Just nip that in the bud. And at minimum, it may violate the employee's policy, or the employer's policy, I should say, right? So just FYI. Okay. So scenario number 5, we've got Vance transitioning genders, and once the transition is complete, she will prefer to be called Vanessa. Vanessa has notified her boss, Tom, of the transition intention. Immediately, Tom tells Vanessa that her transition is unacceptable. Over and over, he tells Vanessa that the change is inappropriate, then he immediately terminates her employment. Okay, so let's talk about this. Do you think Tom's reaction to Vanessa's transition is illegal? Yes or no? Wildly illegal was the comment. Yeah, so everybody that said yes, you're right. Absolutely. Starting in January, there's a new SB 396 amendment that expands protections available for people who identify as a transgender. Okay? They also expand protections for gender identity and gender expression. And California has adopted similar regulations in the past, such as gender-neutral bathrooms, to ensure protection, but this new amendment really spells it out. You can't retaliate. You can't terminate. I mean, there is no difference between a hostile work environment and this situation. And by the way, this was a true issue. It wasn't in California. Actually, it was in South Carolina, in which Vanessa won in court because of Tom's behavior. But I'm using this example because it is happening. So let's dive into this new SB 396 amendment, right? Under this new amendment, California gender expression is defined under regulations as someone gender-related behavior or appearance or perceived behavior or appearance regardless of conformity to stereotypical behavior and appearance for the individual's sex-assigned birth. Meaning, okay, that you've got a couple things here about sexual expression, gender identity, and transitioning. Gender identity is a person's understanding of their gender or perception of their gender identity, which may include male, female, combination of both, neither, however you want to say it, a gender differing from the one assigned at birth, or transgender. California's regulation adds a definition for transitioning to ensure that no employee or potential employee is discriminated against while transitioning. Transitioning is defined under the regulations as the process some transgender people go through to begin living as the gender for which they identify rather than the sex they were assigned at birth. And there may be a transition period. It may include alterations in the name or the pronoun usage, the use of facilities, engagement in office-related activities, or beginning hormone therapy, surgery, or other related medical procedures. And I'm going to say this. Employees may not discriminate or retaliate against a person who has transitioned or is in the process of transitioning or is believed to be transitioning. In the above scenario, Tom has illegally discriminated against Vanessa due to her announcement to transition from male to female. Okay? Additionally, employers may not request an employee to disclose information related to sex, including gender, gender expression, how they view their gender, or gender identity unless it is requested on a voluntary basis for record-keeping purposes. Further, employees cannot inquire about or request documentation or proof of someone's gender, gender expression, gender identity, or gender sex. Other notable expanded rights in the new regulations include those related to work conditions, job performance. Employers must allow employees to use facilities that correspond with their gender identity or gender expression, not the sex assigned to them at birth. Further, single occupancy facilities under the employer's control must be labeled with gender-neutral terms, such as unisex, gender-neutral, or all-gender restrooms, by the way. Just giving you heads up for those that are owners, you might need to do something different with your restroom titles. For a job performance, employers must allow employees to carry out duties that correspond with the person's gender expression, not the sex assigned to them. Okay? Employers should review their policies to ensure full compliance with the new regulations and implement a comprehensive transgender policy. Addressing the gender transition plan, the legal name change and personal pronouns, restrooms, so on and so forth on there. Okay? So what does this mean? It just means stuff that we should have been doing already, if you want to be honest with you. The biggest thing is that everybody brings talents and gifts to the table. Okay? It doesn't have anything to do with surface diversity. When the crap hits the fan, can the person do the job? Right? Doesn't matter what they look like in order they need to do the job. Can they do the job? And the answer is, it should be yes, because that's who you hired. You hired them because they needed to do a specific job. Right? So don't treat them any differently than anybody else. Specifically, don't discriminate based upon their preference to change their gender and their identity of changing the gender. They're still doing the same job you asked them to do. And they're still in the trenches with you. So respect should be given. Make sense? Okay. Questions about this at all on that one? That one's the new law, and we'll get into that. Hopefully that just makes sense. You know, there might be some other sexual harassment incidents. Again, it's often subtle in nature. Sometimes it could be jokes, insinuations, off-color remarks. It doesn't have to be anything that you can see. Well, it could be jokes. And I mean by that, texting dirty jokes, sexually explicit images, memes could be one that comes into mind that I see quite often. It could be it doesn't have to be verbal, nude semi-clad models around their desks, so on and so forth. There's just some examples of it. It could be, and again, going into the personal questions of sexual nature, this also could be something that, protects from a transgender perspective. But we've got some nosy people that have no filters. I'll be honest with you. There are nosy people that have no filters, and they'll get in there and they'll start diving into your own business and trying to violate your bubble. And the fact is that you need to establish your personal boundaries. What your personal boundaries are, how do you address it, so on and so forth. So just keep that in mind. Well, vulgarities and other offensive language, I've been privy on that part that, there are some work environments that, are accustomed to colorful metaphors. And I will let you know that according to the 9th District Court of Appeals, The F word is not in and of itself illegal. It is the tonality and how it can be interpreted that makes it hostile. Okay? So just keep that in mind when you are regularly dropping F-bombs everywhere in the work environment, that somebody could take to offense to it. So maybe you can use other things, other colorful metaphors or non-colorful metaphors, or maybe no metaphors whatsoever, for you to understand that sometimes what comes out of your mouth, although you may not mean it, can be interpreted as hostile. Okay? And then, of course, any physical contact that is in there, whistling, touching, that could be considered degrading for any reasonable person. California has also introduced us to a abusive conduct perspective. And this was approved in 2014. Now, let's talk about abusive conduct and basically what it is. Abusive conduct is an employer or employee in the workplace that behaves with malice that a reasonable person would find hostile, offensive, and unrelated to the employer's legitimate business interests. Let me give you a couple examples of this one. All right? Since some of you might be in California and might be 49ers fans or Los Angeles Ram fans, or Raiders fans, or Chargers fans, or, you know, any type of fans like that. I live in Denver. I'm not a Broncos fan, but as soon as you say Broncos to somebody who's a Raiders fan, there's some instant hostility because there's a rivalry between the two. But even more, I'm a huge Seahawks fan. So anybody on here that is a 49ers fan or a Rams fan may not like me. And if we work together and you keyed my car because my Seahawks just cleaned the clock on the Rams or the 49ers, that could fall underneath the abusive conduct behavior, right? And I could file a claim. Because A, why? It's just a game, first of all. But second of all, you keyed my car because my boys beat you, right? By 1 point at the last minute in L.A., right? You could find it, yeah, definitely that could be hostile, offensive, and unrelated to an employer's legitimate business interests, right? It's just an example. In this day and age, when there is a political football that is a hot topic and it's all about the president in the Oval Office that we're talking about, that could be a tough topic. And there are a lot of emotions and passions behind both sides. Okay? I will tell you right now that if people start getting hostile towards that in the work environment and those discussions get heated, you could go down this line. And that's a dangerous, slippery slope, folks. The whole idea about the work environment is that it should be a safe environment. That's the whole idea. And I've had this, when I write this, I wrote this course for the on-site version, and I gave you an example of a scenario in which you had somebody that actually hung a Confederate flag in their cubicle, and somebody took offense to it. Well, if you don't take that down, you're going down this road. It could be considered abusive conduct or hostile work environment. And invariably, somebody comes in and says, Russ, what about free speech? What about free speech in the work? Isn't that, our First Amendment rights? And I'm telling you, if your behavior, including your speech, including what you display, is considered offensive to somebody else, that a reasonable person would find hostile and unrelated to the employer's legitimate business interests, you need to take it down. You need to remove it, and you could be opening yourself up for a complaint. And I'm telling you, we don't want that to happen. Okay? So, again, this is a safe environment, and it should be a safe environment. So if you've got overtly strong political views that you want and willfully try to cram down other people's throats, you're going to open up yourself for litigation if you're not careful. Okay? So keep it to yourself. Make sense? Or if you are a 49ers fan and you are upset about the Seahawks and you key my car, or you set my Seahawks shoes on fire, or something to that extent, whatever. Again, it falls underneath this, right? So let's make sure that you understand that. Repeated infliction, that's a verbal abuse. That could be part of it. Verbal or physical conduct, gratuitous sabotage, undermining the person's work performance. It's just hard to say that it is. If a complaint happens, I will let you know. It's just hard to defend against because perception, 9/10 of the law. Now, underneath the gratuitous sabotage, undermining a person's work performance, keying one's car, so on and so forth, that might be tangible. But a lot of times, it could be passive aggression nowadays. So just FYI. Make sense? Questionable harassment. There are some gray areas. It can be considered hostile. There are some things about sex or age that may not be illegal underneath anti-discrimination laws. It's a gray area. It depends upon your state. It depends upon anti-harassment policy. This is why an investigation is huge. Either way, employers need to put a stop to this. If there's a complaint, you need to take it seriously. Employers need to put a stop to this in order to maintain morale and everybody get back to work. There's a third-party offense issue that you also might need to be aware of as well, and does not require direct interaction with the person filing the charge. And I'll give you an example here, okay? Let's take a look at scenario number 6, where Alan and Jay are in the break room exchanging jokes of a sexual nature, which is overheard by a person. This is third party. Alan and Jay may be actually okay with it, but that third person in the room takes offense at the third party, right? It can create a hostile work environment. It just shouldn't be doing that. What about Barbara? This is also not a third party. It could actually be quid pro quo. She constantly gets asked on a date by the company's customers, and she's uncomfortable with that behavior. And then, of course, Bob says, or the supervisor says, you don't have to worry about Bob, he's harmless. And customer can be a perceived authority. And the supervisor's reaction behavior was wrong. Take it serious. Okay? Bob may not be harmless. He could be a creep. He could be a stalker. It doesn't matter. She's uncomfortable, and you need to take it seriously. Supervisor needs to meet with Bob and tell Bob that we don't tolerate that stuff anymore. There has to be a time in which we begin to protect our employees from some of our creepy clients. And that time starts now. And you really got to think about it. That has to be an issue on it. Okay? So, interesting. So the question is, well, what happens if they have dementia? And I mean, are you meaning the client having dementia? Are you meaning like Barbara having the dementia? The client having dementia? Okay, so that's an interesting situation. And again, that has to be handled by a case-by-case situation, right? Because there's so many other things in there, especially if we're talking about now to protect the class called disability. Meaning, let's say Barbara has dementia, right? Then that's a disability. Different type of protected class. Well, that's something you got to tippy toe. And you know what? Who's the best person for that? Is that your relationship manager? So I would bounce that idea and see what can we do to help accommodate Barbara if she has dementia? What can we do to help educate Barbara if the client has dementia? There's some things that we can do about that. But it's going to require taking action and having a conversation in some way, shape, or form. Who the audience is a different story. Great question. Either way, well, it's her choice. If Barbara would like to date the client, that's the other comment here. She is not supposed to date the client. It's like that's her choice. But in this situation, she's uncomfortable with the behavior, and she went to the supervisor. supervisor didn't take her seriously. That opens yourself up for litigation or complaint down the road if the supervisor didn't take it seriously. Now, if she wants to date the client, well, then she can date the client. Just be prepared for the fallout, if there is one. So be careful about that. Okay, so just something to think about as we go down that road. In this situation, it's more the supervisor's actions. Good questions, folks. Good questions. I appreciate it. Thank you very much. All right, pop quiz again. Yes or no? Is this sexual harassment? Let's take a look. Is a female employee wears miniskirts to work? Is this inviting harassment? Yes or no? Good. All right. So the key here is this inviting harassment, okay? Just because somebody wears something to work doesn't mean that anybody's inviting harassment at all. So the answer is no, okay? Now, employees need to abide by the workplace's dress code, obviously, okay? And you're spot on, Pat. Dress code could be a violation of dress code, but if the code permits miniskirts, well, the employees have the right to wear them without being harassed. Okay, point blank. So that's one of the things you need to think about. Now, what about this one? A female supervisor makes frequent comments about a male employee's physique. Is this sexual harassment? Yes or no? Yep, absolutely. It doesn't matter what gender you are. Any gender can be victims of sexual harassment and have the same protection under the law as female employees. Okay, so it's not just female has the right to get offended by any male. It's any gender. All right. Same thing with this one. Male supervisor makes frequent comments about male employees' physiques. Is this sexual harassment? It's the same thing. I'm going to go through that. Yep, these are wrong and should be stopped. Now, more pop quiz. Here we go. Two coworkers forward each other off-color jokes they receive in emails. Is this sexual harassment? I'm curious to see what you folks say about this one. Ooh, okay, so now I'm starting to get folks that are, all right, we got a yes, we got a no. Okay, so in and of itself, the two coworkers, this is not sexual harassment because they are engaged in doing this together. However, it can violate your email policy at your workplace. Okay? And if one of the employees suddenly complains of sexual harassment, the claim probably wouldn't stand, mainly because the employee had been participating in it. Now, if one of the employees decides that the exchange is no longer welcome, big story, different story. They need to communicate this to the other employees, and the other employee needs to stop sending the jokes. Okay? And that's the key about this. So now, what happens when a person oversees the jokes on the employee's monitor? Great question. Now, that's third party. And that could be considered a hostile work environment if the person overseeing it took offense. Absolutely. So then that goes down the road. But the exchange between these two probably isn't sexual harassment at all. Good question. So an employee asks a coworker out, is this sexual harassment? Let's go assuming that this is one time. Okay, is it sexual harassment? I think I've kind of got into that. Nope, you're absolutely right. The first time, asks a coworker out, but then if it's, Captain Creepy and constantly does it, then it could be an element of sexual harassment. Now, here's the thing. Somebody said no unless it's unwelcome. The employee says, no, I don't want to go out with you. Thank you very much. I don't want to go out with you. And that's done. And it never happens again. That's not sexual harassment. It has to be, in this case, consistent. Or there is, and this is an employee of coworker, so there isn't a position of authority. But if it was a manager asking a coworker out, and there's an adverse employment action that happens, then that could be quid pro quo. So good. An employee posts a male pinup in her work area. Is this sexual harassment, yes or no? It can be, yeah, and if somebody takes offense to it, it is. All right, so you will be asked to take that down, flat out, right? And if you don't take it down, well then you could be subject to disciplinary action. Okay, good. Everybody's paying attention. You're all looking at me like, yeah, really? Is that the case? Yeah. These are some of the cases in which people think it's still okay to do. Okay, and I'm telling you, nobody's above the law. Obviously, as we're starting to see the fallout of all these prominent individuals in the media, Kevin Spacey's of the world, and the Harvey Weinsteins of the world, and the Matt Lauers of the world, and who's that chef that just got it, that just did it today, and the Louis C.K., all that kind of stuff in the world, Al Franken, you know, nobody's above the law. I mean, these are situations in which if somebody takes offense, yeah, Mario Batali, thank you very much. If somebody takes offense to this, you got to stop this. But they also got to let you know that they took offense to it. I guess that's the first thing, and then give you a chance to stop doing it. Okay, that's the big thing. So. Now we get into, okay, I'm going to skip over that because we already did that one. So, what if you feel you've been harassed? So, a couple things that you need to do. The first thing that you need to do is you need to do, when appropriate, tell the person no. Okay? Tell them what it is that's going on, ask for them to stop, and then if there's no improvement, follow the company procedures. As an employee, this is your obligation. This is what your duty is. You need to let them know, okay, in some way, shape, or form. And if it is your body language, that's fine. If the act, though, is so pervasive that you are so shocked by their behavior that you can't tell them no, then you got to report it to management or human resources. But really, in most cases, tell them to stop. Okay, that's the big thing. Tell them to stop. I talked about retaliation. This includes if you tell them to stop and they still continue, or they don't include you in meetings anymore, or they don't include you in emails and all that kind of stuff like that. That could be subject to retaliation, and that could be interpreted to retaliation. Okay. So it is by some element of punishing, by moving from different departments, less desirable shift, not included, all that kind of stuff like that. I just want to let you know that perception is 9/10 of the law. So if I perceive that I'm being retaliated, I may be retaliated, and it might be valid. It's hard to prove against once this goes to a case. Okay? So it's just something that you need to think about. Victims may be entitled, obviously, to the damages now, even though they've not really suffered a tangible loss. Pain and suffering is included as compensatory damages in some of these cases. And I just wanted to let you know that, as a victim. Now, that being said, I've had this before, and I'm just going to throw this out to you now, okay? I've had employees that have been on here and says, well, does this mean I get to sue? Does this mean I get to sue? Does this mean I get to sue? And now you're starting to look as another source of income. As soon as you do that, accusers have rights too. And this is why investigations are huge. Okay? And we'll get into this for a bit. But accusers have rights just like victims do. And somebody who thinks that this is going to be a money grab and this is going to be an easy way to get money through settlements or claims, they're sadly mistaken. All right? And even worse, it kills the morale. It creates a toxic work environment. It can even shut down a business. So if you're thinking that it's a money grab, don't even do it. Okay? It's just, you're going to abuse the system, you're going to abuse it, and you're going to ruin it for the rest of us. Okay? So don't do a stupid thing like that. Make sense? So why don't employees report harassment claims? Well, a couple things is this huge one about it'll do no good, so why bother, right? If your employees don't take the harassment seriously, or if your management doesn't take the harassment seriously, they're going to hesitate to come forward, right? Leaving you open to possible liability later, right? There's also the fear of retaliation. I've talked about that. There's the fear of being ostracized. There's labels, being called prudes, or, not a team player, or, complainer, whiner, all that kind of stuff. Or there's the other option of the nuclear option, where some employees don't come forward because they are concerned that the situation might be blown out of proportion, causing them even more embarrassment, or that someone will be disciplined unfairly, maybe even fired, and all they want is the behavior to stop. I was listening to the news the other day, and we had this situation, and I just remember on the radio, the person said, I'm in HR. And when somebody in HR hears that somebody else, when there's a complaint, that person's automatically, the accused is automatically terminated. And I went, whoa. You can't do that. I mean, you can. It's an at-will state, but then guess what's going to happen? You do that, then you're going to have a suit for unlawful termination. If you don't go through the proper processes and steps pertaining to an investigation, right? It's huge. You can't just arbitrarily fire somebody because of a complaint. Do the proper steps, right? But let's talk about your complaint. So if somebody complains about you, what do you need to do? You need to stop. Don't wait for anybody, and probably apologize. In fact, that's what I think I would do more than anything else. Okay? If there has been an honest misunderstanding, if they have interpreted your behavior and wrong, in other words, we judge people by how they behave, we judge ourselves based upon how it intended. And the key thing here is, if you didn't intend for it to come out that way, you need to apologize and make sure that you do everything in your power to move forward, right? It makes it a lot easier when you apologize, right? If you didn't know that your behavior was unwelcome, well, now you do, right? Let them know that you appreciate them bringing this to attention. It's huge. And obviously you didn't mean to, and again, you need to apologize. Don't retaliate, don't shun, avoid, or start gossip about the person that complained about you. Okay? You don't have to be best friends, but you do need to be professional, right, and cordial. And if it was someone you supervise who is otherwise subordinate to you, then you need to be careful, because that retaliatory employment decision could be interpreted, meaning that they've done a heck of a job, and you rate them a needs improvement because of something that isn't documented, because deep inside you took offense to what they said that they took offense, right? I mean, that could be retaliatory. Just like, pride and ego in a position of authority shouldn't happen. I shouldn't say it isn't allowed, it does. 80% of the people operate underneath that. I'm telling you, right now, it's not a good leader when you operate underneath the position of title, right, and the ego that goes along with it. How do you know if your behavior or any behavior is considered unwelcome? Well, take a look at the first one. Unfortunately, the unwelcome cues from the recipient aren't always clear. So on your question field, what would be cues that may indicate somebody didn't like what you said or is offended by what you said? What are some unwelcome cues? Good. Body language. Tell me more about this. Okay, good. Frowning, not laughing. What else? Facial expressions, such as, what would be some lack of eye contact? That's what I'm looking for. Yep, good. What else? What else? Body language, walking away, avoidance. Yeah, they don't even email you anymore, talk. Yeah, well, that's the other thing, too, about avoidance, Michelle. I'm glad that you said that. They don't respond to your emails anymore. right? They don't attend to the meetings anymore. If you have a company party, like a Christmas party, they don't show up for the lunch anymore. Yeah, that might be considered elements of avoidance. Short with conversating. Yeah, direct to the point, one-word answers, right? Usually associated, if it's face-to-face, with lack of eye contact, arms crossing, rolling into the eyes, all that kind of stuff. Look, you have to have your radar on, and you need to pick up on those cues. And your brain does it better than anybody else, but sometimes your mind's so wrapped up in other things that it doesn't allow your brain to talk to you, right? It's just some of the things you need to think about. And look at that last bullet point. The very same thing from one person might be okay, but it could be considered offensive coming from somebody else. We've got different filters for different people. Seriously. And when we have filters for different people, it tends to generate a double standard, and it could be hypocritical. So it's just something you need to think about. But yeah, are they frowning? Are they walking away? Are they smiling and engaged in returning your remarks in kind? If you find yourself, I love this, hesitating to say or do something because it may cross the line, they probably will. Okay? So let's talk. So that's good. So as an employee, you need to tell people no. Okay? As a manager, if somebody tells you that your behavior is unwelcome, you need to stop, be aware of it in some way, shape, or form, verbally, non-verbally. You need to be in tune with that, and you need to apologize, right? But you have other things that you need to do as a manager. Okay? One is enforce policies and set an example. Do you know what your policies are for employees to make complaints and an investigation, and for the employer to investigate? If the answer is no, that is the first thing that you need to do. Reach out to your RMs. Either find the information or reach out to the RMs, and we'll help build that information for you. RMs is your relationship manager, okay? I will let you know that the policies should include provisions to fully inform employees of their rights and what they need to do to secure those rights. So it's not just the victim's rights, it's also the accuser rights, okay? Huge. It should also include steps for prompt, complete, fair, effective investigations and prompt corrective action if the allegations are proven, okay? Including appropriate action to stop the harassment and ensure that it will not continue. And then finally, the policy needs to address the issue of remedying the victim's damages, okay, if there are any. This might include a hiring or job reinstatement, promotion, back pay, so on and so forth. And all these policies won't do a dang lick of good if nobody knows where the policies are. Okay, so you need to post and distribute your employer's policy and train all new staff during orientation, or come to me on these webinars, or do it online, or do it on site with one of our folks. And by the way, as a leader, see the last part says workplace inspections. Let me dive into this. Because, I mean, you're not having Gestapo-like inspections. I'm just talking leaders need to walk around. Okay? And as you can't be effective leaders by not walking around and seeing what's going on. And when you're walking around your job site or work area, speak of visual inspection of how these people set up their cubes and design their cubes. And if there is something, like a poster, like a Confederate flag, like a calendar or something like that, that could be considered hostile to the workplace. And in California, that includes political bumper stickers as well. Just giving it. Somebody asked me that a while ago, and I'm like, yeah, that includes that as well. Ask them to take it down, take it home. Okay? Because if you see something that could be considered offensive, it probably is to somebody. So, again, just that's your duties. And by the way, the best way to lead is by being visible. So, FYI. Harassment policy guidelines, I already talked about that, but really I'm going to stress it again. Procedure for employees to make complaints and include provisions to fully inform employees of the rights and what they need to do. Okay? All right, I'm laughing because, yeah, because there was a comment that was made. Yeah, I'm sure I know what it is, but the political environment is hotly charged right now. So I'm sure when I was bringing up somebody posting a bumper sticker of a political comment or a bumper sticker in California, that's discrimination if somebody finds hostility for it. So some of you might be appreciative that you are not in California for that reason, because you would be in trouble all the time, I would assume. I'm just saying it's like that might be the case, but your state that you might be in might also have these type of discriminatory protections for political, sexual orientation, political views, age, ancestry, so on and so forth. So I would check your state before you say, thank goodness that you are not in California. So, make sense? Might want to check. So here's some policy guidelines. I was talking about that earlier. Steps for prompt, complete, fair, and effective investigations. It's basically that thing that I just said earlier, so FYI. So why do you need to know about harassment? This is huge. Because if you don't know what's creating the toxicity in the environment, how are you supposed to mitigate it? How are you supposed to nip it in the bud? Right? In addition to, obviously, that the company may be liable if no action is taken. Right? But also, look at the third bullet point. You as a leader, you as a manager, you as a position of authority might be considered an agent, so your actions might, also hold the employer liable. But if the issue is so pervasive and severe, you can also be held personally liable. And if that liability can be from the standpoint that you didn't do anything, you didn't follow your anti-harassment policies, right? So you might be personally liable. So it's something that I want you to think about. That do you have? In fact, I'll give you some data. The largest personal liability settlements was $18 million. Now, that's a whole heck of a big thing that you had to do to get that judgment that high and that settlement check. But do you have 18? Is your actions? Do you have $18 million in your back pocket you're just willing to do and willing to throw away on something like this because of the way you acted, or you didn't take it seriously, or you didn't follow your company's procedures? I'm just saying. It should be common sense, but we know from a Mark Twain perspective that common sense isn't so common, right? We should, from a leadership perspective, we know we should be taking care of our employees. All right, that includes the victim as well as the accused. Okay, and you need to take care of them, and that means that you need to have solid policies in place to protect both of them, and do your investigation and do it right. Now, how do you do an investigation? I've been talking about it, so here it is. First and foremost, you need to take the information seriously, okay? Act on it. This happened up in the Northeast, and I will give you an example. There was a gentleman that was wearing a Gadsden flag hat, and the EEOC got involved on this, by the way. A Gadsden flag hat is the flag that says, "Don't tread on me." It was designed by a gentleman by the name of Gadsden. And, it's very prominent in the Revolutionary War. And it literally was a snake, and it said, "Don't tread on me." And the gentleman took offense to this because it had connotations of slavery. So he went to management, and management, complained to management, and management said, yeah, right? Yeah. And so 2 weeks later, the guy's still wearing the hat, and the person that took offense went back to the manager and said, "You guys haven't done anything." Yeah, we'll take a look at it, blah, 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 blah. Well, nothing ever happened So he filed a complaint with the EEOC, and the EEOC came in and said, show me the investigation documentation. And they didn't have it. So guess what happened? They charged this company with violating that person. It was a racial discrimination complaint. And they found validity in it. And it wasn't because it was the right or the wrong thing. It was because the management didn't take the complaint seriously. Okay? So that is why you want to do it, because if not, it could cost the company money. And from a personal liability perspective, it could also cost you money. So anytime anybody has a complaint, take it seriously, please. Okay? And look at the rest of it. Investigate promptly. The individual conducting the investigation needs to be knowledgeable. Interview the company claiming sexual harassment, or interview the employee claiming sexual harassment or abusive conduct, so on and so forth. Now let's take a look at that last bullet point. Document, document, document. In my case study I just gave you, if it didn't document, it didn't happen, the EEOC comes in and says, where's the documentation? And if you don't got it, who do you think they're going to rule in favor of, right? It's just one of those things you need to think about. So what do you document? All the facts, dates, times, witnesses, so on and so forth. Use these open-ended questions such as what, when, where, and how. Okay? Use stuff and interview any potential witnesses. Inform the witnesses that retaliation also is strictly prohibited. Okay? Interview the accused with the same guidelines as before. Document, document, document. And then attempt to reconcile conflicting statements. Right? This is the huge part of it, is that it's like what a divorce judge once said. There's his side of the story, her side of the story, somewhere in between there's the truth. That's what you're doing when you're trying to reconcile the conflicting statements, right? But if you have all your notes copiously written down, it makes your job a lot easier to find out where the truth is. And if there is an element of lack of credibility. So how do you judge credibility? And look at these bullet points, right? If you're hearing conflicting stories about what happened, here's some things that might help you determine whether the victim or the harasser or witness is likely telling the truth. Does it make sense, right? Do we have tangible evidence? Did the witness see it firsthand, or is it hearsay? Is there bad blood? Is there a motivation to lie? Is there any moral objections to the behavior of either party or the alleged behavior itself? I mean, this is a checklist basically when you're looking through this. Do they have a reputation that makes the witness assume certain behavior? Like, oh, that always did that. It must have happened because that person was blah, blah, blah. Right? So that's the key things there. Make sense? And then determining if it's illegal harassment, well, this is some of the things of, did it offend others? What was the context of the remark? Mildly offensive? How often did it happen? Did the victim ever object to the behavior before? It's just some of those things that you need to think about determining if it is illegal harassment. And then there's two types of complaints that could result in the finding of no harassment. A legitimate complaint, okay, of perceived harassment where the investigation, would not have been offended. So somebody files so many complaints, okay, and it's not considered illegal harassment if you do the investigation and that reasonable person would not have been offended, right? It's like, okay, so it happened once, the person's bad, it feels bad about it, will never happen again. Now, it's just, it might have been minor, but it could have happened. The other one, an illegitimate complaint where false information was knowingly provided by the complainant. Okay, let's talk about this. Somebody has lied to you in order to cause trouble for another employee. Okay? Here's where you either really reach out to your HR team. And by the way, either your RMs, your internal HR team, however you have the structure set up, these are your greatest assets. This is years of experience here. That is your ally. Okay? And I know that in some cases, they operate from the grave because nothing's really cut and dry when it comes to HR harassment claims, right? I mean, there might be some from a severe, yeah, obviously that is this kind of stuff. But I will tell you that they're so good at operating from the gray that you need to really bring them in on this. If you're not sure how to handle a harassment complaint, they are your best resource and your greatest ally. And in this case, when you got somebody that deliberately lied to you to get that person fired or to file a complaint against somebody, that's where you need to bring in this. This is serious, right? And it's really similar to somebody falsely accusing somebody else of stealing. It's that type of thing, and it's really essential that the investigation that you do is conclusive, and your findings are certain before you decide what action to take about this person. Okay? I don't know if, in this day and age, I really don't know if false complaints of harassment are very rare anymore. It used to be the case. But if you're taking all of them seriously and you're handling them the proper way and you're bringing in the right resources to do the right investigation, then you're going to know if a person's lying or not. Okay? On either side of the fence. Then you got to do something about it, right? Before you do that, you need to conclude the investigation. So this is one of the things that is very interesting as well. Okay? See that first bullet point? It says make a final decision. Just please make a decision. If you leave it hanging out in limbo, the issue is this. It'll never get addressed. There's more opportunities for retaliation. It could fester and become toxic, right? If you determine in the investigation that the harassment has occurred, then document and do the right discipline, okay? Don't forget to let the victim know what the findings are. Make sure that you check up periodically, okay, to make sure that that still has, that the abuse or the violation is not continuing, obviously. Document, and when you're done, document some more. And then make sure that the investigative documentation should be kept separate from the personal files. Now, a couple things about this investigative documentation that, although this is probably later on in this slide, but I just want to hit it right now. Nothing can be anonymous anymore, okay? You need to reassure to the victim that you will try to keep it as confidential as possible. But you can't say it'll be 100% completely confidential anymore. That just isn't the case. And there are court decisions that have prevented that from happening. So make sure that the investigative documentation is as best confidential, and the investigation is, and the communication is at best confidential as best as you can. But you can never guarantee anybody anymore that everything's 100% confidential. So I'll include in the documentation that you have. So just heads up on that one. Speaking about documentation, here it is. Again, you want to take a screenshot of this, you're more than welcome to, but always document who, what, when, where, how, so on and so forth. Witnesses, evidence, everything in there. I mean, warnings against retaliation, what the victim wants, what you're going to do, any history, all that kind of stuff. So if you've got that, that's great. But document, and you're covering the basis for your victim, you're covering your basis for yourself, and you're covering the basis for your company when you document correctly. And if you don't know what to document, let us know. We've got documentation templates that you can use. Okay? What about discipline? Just want to check on our time here. Discipline, well, it really, really depends upon how serious the violation. And the disciplinary actions swing from there. It could be a coaching session, which you got to document. It could be a written warning, final written warning. It could be an adverse termination. It could be a whole bunch of different things, all right? But you need to, if harassment has happened, you need to discipline the harasser, okay, in some way, shape, or form. And if you don't know what that level should be, that's where you need to reach out to us, right, or reach out to your HR team, either one. Okay, and again, here's that confidentiality issue as well. Okay, you can just let them know if the appropriate action is being taken. Any questions so far? We doing okay? I just want to make sure that I'm not killing you here, because I want to give you time to ask questions, but I'm trying to be as thorough as I can. Okay, good. Now, see that last bullet point? It is also important to recognize the harasser's rights. All right. So victims have rights, harassers have rights. You got to make sure that you put there. Okay. So, in a nutshell, again, California law makes me do this for 2 hours. I could have just showed you this one slide and say, don't do stupid things, right? But in reality, everybody owns something from that. And from an employer perspective, you got to build your policies. You've got to put it in the handbook. You got to let everybody know where these policies are so they can quickly access it. Some states require posters. All right. Do you have those posters displayed where people can easily see it? Right. Notice that the outside of chain of command reporting, HR is a different manager. I mean, all managers should be well versed in what the policy is and what the process is. And if they're not, well, guess what you got to do? Okay. So if you're an owner on this call, if you're a senior executive on this call, you're underneath the employer role, you're underneath the manager role, and actually you're underneath the employee role as well. Management folks, they need to enforce your policy and enforce the laws, encourage reporting. If you go, yeah, oh, he's harmless, she's harmless, blah, 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 that kind of stuff, get back to work, suck it up, buttercup, whatever it is, that kind of stuff, you're really not encouraging or reporting, are you? Right? It should be easy for your employees to know where they need to go if they have a concern. And that goes with you as a manager. And at the same time, understand that if you don't, you could be held personally liable for that. Is it possible to provide previous slide and this slide to keep on file just in case? Do you mean like a copy of it, or just for your records, or what do you mean, Michelle? Are you talking about? Okay. Yeah. Hey, Todd should have sent out everybody a copy of this deck. So this is on page 55 and 56 of that deck. And if not, let me know. But I'll have Todd resend it out. Well, actually, if you've got your toolbar on the right-hand side, you have something that says handouts 1 of 5. So on the right-hand side, if you expand your toolbar, if you've got something that says handouts, you should be able to, this handout right here, actually I'm showing you on the screen. Is it working? Yeah, there it is. Okay, it's just taken hours. There it is. So you've got this. You should be able to download this or save this or as a PowerPoint, print it out, something like that. So you're more than welcome to do that. It's in there. Forgive me in advance if I had any typos. I tried to catch everything, but I think I caught one that I didn't do capitalization. So don't hold it against me. So, but it'll be on there as well. And in addition, Todd will send out the PDF if he hasn't done it already. But we got you covered in some way, shape, or form. But getting back here, and great question, by the way, getting back here with the management, act immediately, take everything seriously, please, and document, right? And I know that there's people out there, there are employees out there that go, I don't want him to get in trouble, I don't want her to get in trouble, I just want somebody to know about it. Still doesn't matter. We need to tell this person to stop behaving this way, at minimum, right? If the investigation shows who this person is, because it may not be just you, it might be other people, right? So it's just something to think about, right? And then finally, as an employee, and everybody on here is an employee in some way, shape, or form. Oops, I just got through there. If you are offended by what's being said, please let them know. Take offense. So that's the big thing. And it's something you need to, let them know that that's not acceptable. Communicate your personal boundaries. This includes also, if you do have those huggers, what your bubble is. So make sure that they don't violate your bubble, right? Just some of the things about it. Report these incidences too. I mean, feel comfortable that you can report to somebody in management or HR or us about some incidences in there. And when we're done, I'll give you our phone number so that way you'll be able to reach out about it. So what can you do about harassment in the workplace? Well, hopefully we've brought this to the forefront of your mind because, God knows that the media is bringing this to the forefront of your mind. It just seems more of a relevant conversation to have nowadays. But, make sure that everybody knows where it is, what your policies are, and so on and so forth. Do everything in your power to make sure that you've got a healthy, productive work environment. That's the name of this program. And it is important to understand that this could be the last bastion of some people's sanity, your work environment, right? It needs to be a fun place where people need to go, not where it's toxic and destroyed and unproductive, because that could affect the business's bottom line, that could affect your bottom line, and people will leave, right, if it isn't addressed immediately. So that's just some of the things you need to think about here. Make sure also that if you're an employee and somebody's crossed the line, please don't. All right? People need to stop this behavior because it's just happening all the time. It is weird. Leaders need to conduct a prompt and fair investigation, come to a conclusion, and also take disciplinary action if you need to. Now, if you have any questions, thoughts, views, concerns, and you're upset about, everything from harassment to what is the process, needs of policies, developments, and so on and so forth, our HR Service Center is right here for you, okay? And there's the number. So, again, screenshot this. It's also on your downloads, everything like that. We want to make sure that you have ample resources to be taken care of and have all your questions taken care of. And then also, earlier today, a lot of people got on the question field, and I love it. Thank you very, very, very much. And told me who's in the rooms with you, because obviously you kind of know if you've been part of my courses before. It's like there's a lot of people that share their screen. So, I mean, if you'd like a certificate from today's webinar, Mr. Gurley, my good friend and my partner, this is his email address right here. And he'll be, feel free to reach out to him. We'll get you some certs for you because we want you to get taken care of, right? Any questions so far before I let you go? Questions, thoughts, views, concerns? Hey, how often do we host this webinar? Great question. So we do this once a quarter, and the next one is going to be the last Tuesday, I believe, in March. And so we do this once a quarter, 4 times a year. Oh, yeah, can I put on Todd's email again? Yeah, it's right there. We do other webinars too. So we've got some new stuff coming out. We've got a coaching webinar coming out. We've got, if you've ever been interested in some of the new DOL regulations, reach out to your relationship manager, and they will get you those links that you can register. We just don't do this. We do other stuff that is huge and powerful to help you just be successful leaders, right? Has this one been recorded? Yeah. It has, and we're going to throw it up on YouTube, and we'll send out that link, that YouTube link, so you can actually see it again as well. The challenge is, when it's up on YouTube, I don't know who's attended. So if you are in California, there really isn't any type of proof or traction or anything like that. As opposed to here, I know exactly who you are, and online and on site. So if you throw up the YouTube California, it may not work. Is there a resource where we can view a calendar of all the training you are offering? We're working on proofing Q1 right now. So I will send Todd an air quoting, a draft, but it's pretty much polished, for Q1. We do it in quarterly notices. We'll send it out to you. So if you're interested in some of the good stuff, but we got diversity, coaching, customer service, so on and so forth. Yeah, be happy to share that with you. But good questions. All right. Hey, we got Tony on there for the Borrego Springs as well. We got them taken care of. We see that, so we'll make sure that everybody get out in there. Is there any other questions at all? I sure hope you got something out of this, and make sure that your folks are Weinstein and Lauer proofed, for sake of a better word. Good luck. If you have any other questions, feel free to email us. Take care of us. There is a survey I will let you know attached to the end of this course. Take it if you like to. Let us know how we did. All right, we always want to improve, and if you like it, that's great. If you want more, that's great. If you hated it, that's great. It was a 2-hour vacation. It's completely up to you, but that's it. All right, so thanks, folks, for joining us today, and I think this is about as close to a 2-hour window as we're going to get, and you are hereby blessed for the rest of 2017 that you have officially taken it, and you should be good for the next 2 years. So we'll see you in 2 years. Take care. Have a great day. Enjoy. Happy holidays, everybody.